This is Professor Higgins, and I want to welcome you to Lecture 2 of Business Organizations. Tonight we're going to be discussing the law of agency. Now, the law of agency is something that touches every single business entity that we're going to be talking about this semester, all the way from our sole proprietors through corporations. You will find the law of agency at work. In general, I will introduce you to someone I like to call IP3. Now, he's not a Star Wars character, but I call him IP3 because he is innocent third party. The law, at least the state of Florida, loves the innocent third party. We will always protect the innocent third party whenever we can. So when you have an agency relationship where you have an agent and a principal, the law will always look at how it is going to impact, how that relationship impacts an innocent third party who might be involved in that relationship somehow. So every business entity, like I said, has some law of agency involvement in it. You have an agent-principal relationship. It applies to all business relationships. For example, let's just jump into this. An employee of a sole proprietorship may be the agent of the sole proprietor. In fact, they usually are in the business relationship, and they are always an agent when they are in the course and scope of their employment, when they are carrying out duties for the sole proprietor. The employee is always an agent. Partners can be agents of a partnership. Partners can even be agents for each other. A manager of an LLC, which is, we talked about last week, a limited liability company, they are often deemed agents of the members of the LLC, who are the owners, if you remember. Okay, directors, not only directors, but officers as well can be agents of a corporation. So in all of the business entities we're going to talk about, when we have an innocent third party who is doing business with that particular entity, we will look to see, especially when we are talking about litigation, we will look for relationships such as agent principal, and we will be governed by the law of agency. All right. Just to give you a quick these are the definitions from the book, and a little redundant, but I want to go over it here in the lecture. The agent is the party who acts on behalf of the principal. The principal is the party for whom the agent is acting. And the law of agency governs the relationships between principals and agents as it relates to their interaction with innocent third parties. So there you have it in a nutshell. You could just flip off this lecture now if you've got that. But we're going to go into a little more depth this evening on the law of agency because I want to give you some concrete examples of agency. If your client comes to your law firm and asks the attorney to draft a will for them, then the attorney is the agent of the client. A store clerk who is selling clothes is the agent for the company, for the clothes seller, whether it's the Gap or Banana Republic or just insert your favorite brand. The store clerk will be the agent for that company if they are selling in the store in their course and scope of business. A waitress who is serving coffee here at the Denny's across the street from Valencia, she is an agent of Denny's. Me, teaching here at Valencia College. I am an agent of Valencia. Now, all of these are agents, and all of these examples I have given you are agents, and we need to know in the law of agency, if I am working at Valencia and if I harm you as a student, is Valencia liable? If I am in the course and scope of my business, if I am in doing my duties as a professor here at Valencia College, and you get injured somehow, which I've never injured a student yet. It's been years, but I they would be liable to you, and we'll talk about respondeat superior and vicarious liability, because I am acting in the scope of my business. However, if I followed you home and when you got out of the car and I knocked you on the head with a baseball bat, I would not be in the course and scope of my business. Valencia would not be liable for your damages. That would be all on me. And in fact, you would have a civil remedy for your medical bills, and you would have a criminal remedy as well. So the state of Florida would come after me. So I haven't done that either. Sometimes I use outrageous examples just to keep my students interested and paying attention, because I want to make sure that you're getting this stuff. Okay. I want you to, let's see, I want to talk about how agency relationships are created. There are several ways, and I love your book. I love this chapter on the law of agency, so I want you to read through it very carefully, and then after you watch this lecture, hopefully it will kind of gel. That's my hope with the whole semester. I want you to always read the chapter first before you listen to the lecture, and then you will get a lot of information that kind of makes sense, but maybe it's a little hazy, and then I want you to watch the lecture, and that will clear it up, hopefully, if I'm doing my job. In the course and scope of my employment, I will clear that up for you. And as you know, weekly we have our talking time, which we will Zoom, and you will be able to ask questions directly. Okay, so how are agency relationships created? Well, there are three ways. There is by agreement of the party. There is something that we call ratification. And the last one is estoppel. Now, estoppel is a little tricky, so I will take a little more time with that. But an agreement with the party, that's an express agency where two parties have agreed that one will be the agent and one will be the principal. This can be oral or written, and there is no consideration necessary. For any of you who have taken business law, you know that to have a contract, you have to have an offer, acceptance, and consideration. You don't need to have any consideration here. You can have an agency relationship without any consideration. And if that is hard to wrap your head around, think about a realtor, a realtor who is your agent, and they are going to show you properties. You haven't paid them anything. You haven't given them any money or any consideration, and they are working for you. They're taking you around and showing you different properties that you want to purchase. Now, they're hoping that eventually, when you decide on one that they've showed you, that you'll be able to, they'll take a commission off of that. But prior to that, there's no consideration, and it's still a principal agent, law of agency relationship. Okay. So there is the express agency, which is really the most common. And the bottom line is when you have an oral, if it's written, it's very clear. But sometimes when people just have an oral agreement to be principal and agent, and then there becomes a problem, whether there actually is that relationship will go to the question, did the parties intend to enter into a relationship? If they intended and it wasn't written out specifically, then you have an implied agency relationship. So if you can prove that, then you still have the agency relationship. Okay. The next one is ratification, and I like this one. This is where the principal accepts the acts of the agent, even though the agent did not have authority to do the act. And my favorite example is, let's say I am your principal, and I have asked you to please serve hot coffee at this lecture tonight to all of our students. And I told you that, you know what, the thick paper cups I want you to use to serve the coffee, not the thin ones. And so you start and you're serving all of the thick, you're serving the coffee with the thick paper cups. Everything's going along fine. And then we run out of cups. And so you just decide on your own. You're, looking around thinking, what's the best way to do it? You try a thin cup. It seems to work fine. And you begin to use the thin cups, even though I've told you to use the thick cups. If I see that you are doing that, and I don't come over and say, remember I said to use the thick cups, and if we're out of thick cups, let's not serve coffee. If I see you serving the thin paper cups and serving coffee in them, and I don't say anything, then I have ratified that action. I know that you're doing it that way, and I'm thinking, oh, that was pretty smart. I guess it did work after all. Good for her or good for him. And I have ratified that. And then if one of the cups spills on someone, or if the coffee seeps through and there becomes a problem, the agent is still protected by the principal. I'm still the one who's liable because I asked you to do that. And even though you may have done something I asked you not to do, when I see that you've modified it and I don't stop it, then I have sort of said, okay, that's all right with me, and I've ratified it in the eyes of the law. All right, so that one's kind of interesting. And then the final way is estoppel. Now, there is a legal concept and it's known as estoppel, where the courts will conclude that there is an agency relationship because the principal represented to the third parties that the agent will act on his behalf. The third party relies on that representation to his detriment. And if the party that relied on the representation to his detriment, then that holds the person who held themselves out as the principal liable for anything that the agent did. And examples of that, and we'll go into this later in the semester, but an example is if I send someone to the innocent third party's house and I say, listen, I want Joe to negotiate my contract with you. And then Joe goes and he negotiates the contract, and he offers to pay $1,000 for the innocent third party's services. And he does that on my behalf. And then, I was on vacation and I met this other person who is willing to provide me for those services that Joe negotiated with you. He's willing to do it for $500, whatever it was. And if I can't back out of that by saying, "Oh, Joe did that contract." I'm not bound by that because I made the representation to you that Joe would represent me and negotiate the contract with you, and you relied on it to your detriment because if perhaps you could have gotten $2,000 going to someone else, but you promised me. And so if I back out and I go with someone else, then you will have suffered damages. You will have lost money by negotiating with Joe and relying on my statement. I know it gets kind of convoluted, but that's called estoppel. And you can just remember detrimental reliance. If you rely on something to your detriment, then you generally have a suit against the principal, and that is known as estoppel. All right, so that's how another agency relationship is created. All right, so what authority do the agents have? How far can an agent go when they're representing a principal? Well, the answer is, as always in the law, it depends. Now, I don't know how many courses you have taken from me, but those of you who have had me before know that the correct answer to every legal question that you will have, you take a deep breath, you look deep into your history, you pull on your chin, and you say, well, it depends. That's the answer to everything, because every legal situation, it's not like science. These things are not constants. You have not just one variable in your experiment. You have everything is a variable in the law. So it always depends on many variables. But what authority do agents have? Well, sometimes they have actual authority. Actual authority, and it comes in two forms. There is actual authority that is express authority. The acts are specifically authorized by the plaintiff, either in writing or orally, such as a power of attorney. Like if someone has a power of attorney to enter into a contract for someone else, then for the specific purpose, they are authorized to be the agent of the principal. The other type of actual authority is implied authority. It's very similar to how agency relationships are created. The implied authority is the authority to act reasonably in performing the agent's duties and to perform tasks necessary to fulfill obligation to the principal. Okay, so